I love baseball season. This is my old Mizuno glove. I can smell the leather. I miss being on the field. All right. Hey, folks. Patrick Kelleher, elderlawcare.com. Thank you for joining me today at my Elder Law Care Center in Hanover, Massachusetts. Folks, the question today is, hey, Patrick, what estate planning documents do I need? That's a common question I hear from folks that come into our Elder Law Care Center, as well as when I'm teaching my educational workshops in the community. There's no one size shoe fits all in estate planning. Different families, different folks come to the table with different goals, different dreams, different vision, different aspirations, and different assets. So folks, let's talk more specifically about the meat and potatoes, maybe of a foundational estate plan from my experience that everyone ought to have, especially folks 60, 65 and over, as you're journeying into the fourth quarter of life, okay? Foundational estate plan may be a will, but please remember that your will is your admission ticket to probate court. So depending on your asset structure, if you don't own a home and you do not own any other sizable assets, maybe a will-based plan would be okay, so long as you're okay with your affairs going off to the probate court, which is the ugly milk crate. I typically advise our folks, avoid probate court, the stresses and messes of probate court, the economic and emotional headaches of probate court. Why? Because probate court, typically families will hire a probate attorney. Probate attorney is a very skilled attorney. They'll do a very nice job, but they get paid and they'll charge you typically by the firm hourly rate for the year and a half on average time they're working on that probate matter. So you can get a very large bill in a short period of time. So if you want to avoid probate, folks, put a trust-centered plan in place. I say to my clients, you want the treasure chest, not the ugly milk crate. Ugly milk crate, folks, is admission ticket to probate court. Treasure chest is keeping your affairs out of the probate court and creating a trust when you're alive and well, step one, and step two, getting all your treasures into your treasure chest is step number two of that three-step process, what I call three-step treasure chest process. Page 46 of the book, there's a big warning in there, caveat, do not change your retirement accounts. Any qualified retirement accounts should never be changed to your trust directly. There's a different way of doing it. You can name the trust as a beneficiary, but folks, this is not a do-it-yourself program or project. Work with a qualified estate elder law attorney to assist you with that trust funding. Other documents you should have, folks, is what I refer to as the Big Six disability planning, and I'm going to run through them. And you can also read this on our website, elderlawcare.com. Number one, folks, durable financial power of attorney. Durable financial power of attorney. If you're 65 and over, it ought to have what I refer to as enhanced elder law powers. Our power of attorney, for example, is about 28 pages long. It's very robust, very comprehensive. Why, folks? Because you want to have all those powers outlined and delineated in that power of attorney to give your helper, your agent, your attorney, in fact, all these robust legal powers to legally step into your shoes day number one, or day number one when you become incapacitated, to manage your financial affairs. Number two, folks, healthcare proxy. Not the one pager that you go in when you go in for a surgical procedure. I'm talking about a more robust healthcare proxy where you can spell out a lot of your wishes if you became incapacitated or when you become incapacitated in life. Number three, the cousin to the healthcare proxy is what I refer to as advanced medical directives. Advanced medical directives, where you can specifically spell out what type of care you want in a given situation. For example, healthcare proxy, you can pick out your spouse, your children as your agents to make decisions. But oftentimes it's absent. It doesn't have any specific language in there on what type of decisions you want made for yourself. The cousin to the healthcare proxy, folks, is that advanced medical directive, where you can check a box and say, if I'm in a coma with no chance of recovery, this is the type of care that I want. The key is, folks, you articulate and communicate that and memorialize that in writing with your estate elder law attorney when you're alive and well. So when you're alive and not so well, folks, you can have your healthcare agent communicate your wishes for you, okay? Number 4, folks, is HIPAA authorization. That's the Health Insurance Portability Accountability Act of 1996. That's a medical privacy confidentiality laws. Really, really important, folks, to have that part and parcel of your estate plan. Have that in your back pocket, or your healthcare agent, your helper should have that in their back pocket so they can get and obtain copies of your medical records in a time of need. Pro tip, folks, we typically make our HIPAA authorizations for our clients valid for 2 years after their passing. That can come in handy if there was questions of negligence or liability with the medical professionals. Because if you don't have that HIPAA authorization after the person passes, usually the HIPAA authorization extinguishes, expires as well. Number 5, folks, is a living will. Living will, some folks refer to as an expression of your wishes. Number 6, folks, is what I call a spoon-fed directive. I understand it's fairly standard medical protocol when a nursing home resident is no longer eating under their own volition. The medical staff is trained to manually spoon feed that resident or that patient. So really, really important to have clear communication if you don't want that type of care later in life, okay? Folks, I'm gonna throw in an additional one. Number 7, MOLTS form, medical order regarding life-sustaining treatment. And the national version of that is called a POLTS, physician or provider's order regarding life-sustaining treatment. Again, that's an order usually signed off by a doctor, an MD, or a nurse practitioner. It carries a lot of weight and authority. They typically print it out on colored paper so the first responders see it. And again, the MOLTS form, folks, is typically appropriate for someone with less than a year to live. Maybe someone like my dear mom, when she was home on hospice a little over 2 years ago, and when she made that courageous decision to go home on hospice, the MOLTS form is certainly appropriate in that situation because she was diagnosed with brain tumor, which was terminal illness. So there you have it, folks. That's a foundational estate plan. I hope you found this video helpful. What documents do I need in estate planning? Again, there's no one size shoe fits all. Everyone's circumstance is unique in nature. If you'd like to learn more, go to elderlawcare.com. Thanks for joining us, folks, at elderlawcare.com. Look forward to seeing you next time.